On behalf of the Indira Gandhi National Open University's Program on Australian Studies, I take great pleasure in welcoming Elizabeth Hall of the Office of Employment Advocate of the Federal Government of Australia to discuss with her on aspects of trade union movement in Australia and also of the recent legislations with special reference to the industrial relations in Australia. I welcome you, Liz Hall, to have consented to be here this morning and to discuss with me on questions relating to the industrial relations in India. I know that you call it as workplace relations in Australia. Maybe to begin with, I would like you to briefly sketch on the trade union movement and the importance of the movement in the industrial growth of Australia.
Very much so. Early 50s, after World War II, Australia had just started accepting minority immigrants. It was a growth time for Australia. There was the the Snowy Mountains scheme, which had a lot of migrant workers, and all of the towns across Australia were actually growing quite large, and it was a very prosperous time. And along with that came the union movement to support a lot of workers across a lot of industry sectors. Up until the 70s, it was a very strong movement based both in a state system and federally. So the union movement had state-based organisations but were also affiliated to a national organisation. The union movement is also closely aligned to our Labor Party and always had and continues to this day to have strong ties. However, with our accord in the 70s and changes to our industrial relations systems that first started in the 70s, we brought about enterprise bargaining, where we had state-based award systems and federal-based award systems. The only states that did not have those were the territories at this point in time, which was our capital, Canberra, and Northern Territory. They relied solely on the federal-based system, did not have any state-based awards. Moving on towards those, there was changes in union environments where it was a period of super unions in the 80s. A lot of unions combined to conglomerate into more federally based unions with small affiliations into the state. Unfortunately, during that period of time, the unions, during their amalgamation process, were looking more inwardly at themselves, a struggle and a fight for power of supremacy on who was going to be the leader of that union amalgamated group, which meant that their members were forgotten slightly, and as times chose, since that period of time, for whatever reason, and there are a few, the unions have been in decline. There are two very different types of unions in Australia. One which I would call the blue-collar unions, which mainly relate to industry in building, construction, electrical, automotive, and white-collar unions, particularly around finance sector, banking, insurance, so clerical type workers. I would generally call them a more passive union movement because it takes a lot of work to encourage their members to bring issues to the table, whereas in the blue-collar union movements, they were very strong, very vocal, and they had a lot of support from their members. So generally, over that period of time, going through those phases after the amalgamations of the larger unions, we brought about several industrial relation changes over those periods of time. Today, that there has been a definite decline in the union movement and union membership.
Just over there, may I intervene and ask you this question as to whether, like perhaps in the early trade union movement in Europe, there was what was known as the principle of the closed shop. Was it practiced in Australia too?
It was indeed practiced. In fact, it was supported right up until the 1996 changes, which we currently call the Workplace Relations Act 1996. Up until that act, closed shops were a par for the course, very particularly on blue-collar work sites. You might have heard the saying of no ticket, no start. Typically on a building union site, a person would need to be a member of your union. It was supported by management of the organisation as well as the union, because the unions played an integral role at that point in supporting things like OH&S, return to work. Typically on a building site, workers would only work for a period of 3 or 6 months, and then they would leave, and then they would hope to get other work on other building sites. So the union was almost like an employment agency, making sure that people would actually be gainfully employed in other sites. So therefore they provided a lot of services to members, and it was easier to have the union working together collectively with the employer at that point. So the employers were happy to have a no ticket, no start, and it was seen to be the standard thing. However, in 1996, when those changes were made, no ticket, no start was outlawed. It became illegal to enforce someone to join a union, and that became the beginnings of freedom of association. Under the 1996 Act, freedom of association meant that whether you were an employer, you couldn't be forced to join an employer association, and if you're an employee, you couldn't be forced to join a union, or vice versa, be told by your employer that no, you couldn't join a union. It was purely your choice. With that decline, brought a lot of controversy in the union movement about the no ticket, no start, because they had to work harder for their members.
Now, in the process, of course, it is being claimed that the 1996 legislation had greatly contributed to freedom of choice for the labour, and also at the same time contributed to high productivity and efficiency in the manufacturing sectors and so on and so forth. Nevertheless, there are those who do argue that the basic right in terms of collective bargaining, which is built into what is called the trade union movement, as perhaps it is so in this country, in India. Now, what happens to the right to collective bargaining under the new dispensation of the 1996 legislation?
Under the 1996 legislation brought about Australian workplace agreements. This Australian workplace agreement was the first of its kind in the sense of individual bargaining. So with the changes that were brought by the legislation to bring out AWAs, it meant that an employer could negotiate directly with the employee without the involvement of a union. So it was narrowing the focus from a collective group to a single employee. It definitely had a niche market to consider, even under the Australian laws governing across Australia. Even though we had approximately 3,000 federal awards, and I'd say collectively over 10,000 state awards, that still a majority of employees, I would say, and this is purely a figure out of the back of my mind, about 40% of the working population still falls outside an award system. So therefore, that people that were award free could have been on common law contracts or just a handshake agreement. The individual AWA sought to formalise those agreements that we consider handshake agreements to stop the disputes that occurred later down the track. A typical example of this would be if I were to go work for a real estate agent that was selling houses, even though there was an award, quite often under those laws it would be that you couldn't have 100% commission rate until you'd worked in the industry for 2 years. But common practice in the industry was that nobody waited the 2 years and they would give 100% commission. But should the employee leave or a dispute arose, then they would be to the commission because they weren't being paid under the award. So AWA sought to formalise those individual issues and agreements and make them a formally binding contract both for the employer and employee. However, the area that became, by negotiating individually, it meant just between two parties themselves, and it removed the union from, in a general circumstance, removed the union from that bargaining power or even discussions. An employee, if they wanted to have the union involved, would actually need to actually particularly send it in to the Office of Employment Advocate to say that they wanted their union to be involved.
So your agency will be dealing with issues where there is a deadlock between the employer and the employee?
No, we wouldn't deal with the issues in relation to the deadlock. When the 1996 Act came in, all we were interested in is that the employer knew that a union was involved and that they would have to deal with the union to the approval point of the AWA. Once it was actually lodged with us, it was considered, this is the individual agreement, once it was lodged with us, it was automatically considered that all parties had actually agreed to that agreement, otherwise it was null and void.
What kind of a legal underwriting that it has?
In the 1996, it had no legal underwriting until it was actually approved by our office, the individual agreement. And the reason for that is still very much an award-based system. We would have to compare the award that closely fitted that employee if they weren't entitled to a particular award, and we would do what we call a global disadvantage test. So
What's that?
Under the 1996 legislation, it was called a no disadvantage test. So we had to look at the agreement and say, this agreement is no worse off than what the minimum requirements were under the award.
Okay.
For example, and this is a trend across Australia, the working week would be a 38-hour week, working 7.6 hours a day with an hour for lunch. Mm-hmm. To give you an example, in our Northern Territory, some people, being a warm climate, not unlike parts of India, in the summer months were happy to work a 4-day week and have a 3-day break on the weekend, but work a 12-hour day. Now that particular employer would say, I can't afford to do that because I need to pay overtime for you. So they signed an individual agreement saying that they were happy to work at the same rate of pay for 12 hours, but take 3 days off, and they all went fishing. If they didn't have that AWA to do that, then the employer wouldn't have been able to afford to pay the overtime and it wouldn't have been productive. What that employer found, that they increased productivity because he could then have 2 lots of employees working 12-hour shifts and keep his plant running longer and increase efficiency and turnout. By keeping employees happy, it reduced training costs. So it does have its advantages in a niche workforce. But there have been cases where it's been given in an unfair advantage, where particularly, say, a particular employee didn't want to work 12 hours a day. Well, then if that were the case, then the employer would be taken on by a group.
But still, don't you have anything like what is called the industrial tribunals, which would look into questions of deadlock or a disagreement between the employer and the employee?
We have the Industrial Commission, AIRC. They would look into industrial disputes and deadlocks, but that would only be after the agreement has been made for an individual agreement. During the period of 1996, well, up until 96, AIRC played a large role in all agreement making. They were the main body that actually approved all collective agreements. Other than that, people fell under an award. So whether it be state-based award or federal-based award, they were automatically covered under those. Any collective agreement making was all approved by the AIRC. After 1996, the Office of Employment Advocate was a new agency that was created to take on only approving Australian workplace agreements. However, later on, in March 27th of this year, that power has now been given to the Office of Employment Advocate to approve all agreement making. So that's not only individual agreements, but collective agreements and all types of collective bargaining will actually be approved.
So in that sense, would you say that the Office of Employment Advocate is not only a facilitator, but also now practically a kind of an arbiter?
We don't do any arbitration work at all. If there's still any disputes in relation to the approved AWA or approved agreement, that whole process has been simplified radically. That means that there was no actual approval process, because it's considered that once it's lodged to us, it's already been approved by employees, the union and the employer. There's no approval process, there's no checking process, so it's lodged and automatically approved. So now what we have is a reactive process that if someone complains, it is now goes to an arbitrator, which is our Office of Workplace Services. So that's a new organisation that's been set up as at the 27th of March to deal with any issues or complaints that come out of agreement making or disputes about that agreement or the quality of the agreement.
Can you briefly explain to us the major features of this new legislation that has come into place in March 2006?
Yes, the major features of the agreement making is that all of the agreements have now gone to the Office of Employment Advocate, which is all of the collective agreement making. They're all streamlined process, so the no disadvantage test that I spoke of before has been abolished. We now have what we call the Fair Pay Commission that has been established, and because this legislation is so new, they have just brought out recently, while I've been in India, their first minimum wage case that has been brought out. So they've just made a minimum. So under the new legislation, we have minimas now. So we don't have a no disadvantage test. It's just considered that anything below this minima is illegal, and that it can be disputed, and all of those disputes would go to Office of Workplace Services. This minima is varied depending on what industry you're in, but as a below minimum rate, the Fair Pay Commission determines what that lowest rate would be.
But given the fact that trade unions traditionally have been committed to what is called the collective bargaining, and now with the new dispensation, which is practically substituting the collective bargaining to individual bargaining.
Yes.
How would you look at it in respect of what kind of an impact it would have in terms of protecting the basic rights of labour?
There has been radical changes in the way unions have negotiated agreements. Traditionally, they would be on site and be negotiating, especially in larger employers. From day one, they would be doing the negotiating and then taking that back to the table for their employees. Largely these days, because of the decline in the union movement, they don't have the concentration that they did in the past. And in some areas of industries, they have no representation anymore because their bargaining power has reduced, in the sense that they only can represent the members that were actually they can only represent the members of their organisation and not collectively all of the employees, whether they were members or not. And because of the paperwork that they need to actually go through to actually nominate that they have members in the organisation, and those members actually have to sign and approve that the union is acting on their behalf, delays or reduces the impact and the negotiating power that they actually have. So it's removed the unions as a third party at the negotiating table and brought it back to the employees themselves.
So you consider that this is on the right track in terms of, I mean, the new legislation, by putting aside the collective bargaining right on the part of the labour, has made it more effective in terms of the worker for his individual bargaining. It is more effective than before, is what you would say?
I will give you two schools of thought at the pros and cons against what some industries feel, what some employer associations feel, and in the employer or union movements feel. And the first angle, the employer associations and large employers feel that it's actually streamlined the process. It's become more productive for themselves to be able to have a new employee start straight away, have an agreement that they give, without having to go through a collective bargaining process and lengthy negotiations with the union. They feel that they can negotiate freely with their employees, and it increases their productivity and profit levels immediately. They feel that it reduces their time at the negotiating table, and that they can get on with their core business needs. From the union angle, they feel that they've been shrouded in a pile of paperwork and rhetoric in choice, but there is no choice. They feel that they're being squashed at every angle to be able to contribute to the employees' welfare. And they feel that, and some authors feel that it's a breaking down of our current industrial relations system. So there are two very different schools of thought.
Thank you very much for a very interesting discussion on the workplace relations in Australia and the changes that have been brought about in recent years, particularly post 26 March 2006
Yes.
of this new legislation called the Workplace Relations in Australia. Thank you, Liz Hall, for a very useful and informative discussion explaining to us on the industrial relations situation in Australia.
Thank you.